Executive Secretary of the People's Progressive Party, Mr. Zulfikar Mustafa, moved to the High Court last October to challenge the appointment of Justice James Patterson as GCOM's chairman on the grounds that it was unconstitutional and of no legal effect. Additionally, he has asked the court to grant an order rescinding, revoking, cancelling, and setting aside the appointment of Mr. Patterson, and further asked the High Court to choose a person from the 18 nominees submitted to the President by Opposition Leader Barbadian. Mr. Mustafa also contends that Mr. Patterson does not have the required qualifications, neither is he sufficiently integrous to be GCOM's chair. However, on Friday, one of the two Barbadian lawyers representing Guyana in the case, Queen's Counsel Ralph Thorne, essentially outlined the state's written submission, stressing that the application made by Mr. Mustafa lacked merit and ought to be dismissed.
The entire case for the applicant, Mr. Mustafa, was characterized in a statement made this afternoon when he told the court that the President does not have a discretion in relation to the choice of chairman. Now, that is so flawed. What he is telling the court, and in an open court what he's telling the public, is that the names submitted by the leader of the opposition, that the President only has the power to review those names, but that he doesn't have a choice, he must take one of them. Now that is constitutionally and legally flawed, because it means the choice, indeed the choice, is given to the leader of the opposition. That cannot be right.
Mr. Thorne submitted that based on the exclusio rule, the court does not have jurisdiction to hear the matter, and said that the legal draftsman did not intend the appointment of a GCOM chair should be the subject of litigation. The attorney explained that Article 1612 creates an executive power in the President to appoint a chairman, and he stressed that such function is the nature of convention, something not enforceable by a court of law.
But of course we must defer to the ultimate ruling of the court. But if that is the entire case for the applicant before this court, I wish to say that it undermines his entire case, that it continues to be flawed, absolutely flawed. And I do not see. I thought they would have come with something of greater substance, to be honest with you. But if that is their entire case, I would like to think that a court would leave undisturbed the appointment of a high public official by the head of state of this country.
Mr. Thorne further noted that by virtue of Article 161, constitutional powers and responsibilities are to be exercised between the President and the opposition leader, and so he contends that Mr. Mustafa has no standing in the matter. He said it was the President's legal right to appoint Mr. Patterson.
An appointment by the head of state is not to be trifled with statements like that, to say that the head of state is fettered in relation to his power to appoint. That's what he said, that he has no discretion. Now, when you say to a head of state that he has no discretion in relation to an appointment, you are saying that of the 6 or 12 or 18 names that were submitted, the President must take one of them. Now, if that is the law, it means that in effect, the power to appoint is given to the leader of the opposition. I say to the public of this republic, this proud republic, that that cannot be the state of the law.
The lead attorney representing Mr. Mustafa Anil Nandlal was in no-show for the case. Reports are that Mr. Nandlal's unavailability was due to a flight cancellation in Canada. Royden James, HGP Nightly News.